Aloha, and thank you for attending today's presentation. My name is Carol, and I have been with the Senior Counsel Division forever, since its inception. It is my privilege today to introduce our guest speaker, who is back by popular demand, and I've had the privilege of knowing him since at least 2006. And today's presentation will be on closing a law practice and succession planning. I know you folks have read his bio on your own, so I won't bore you with those details. And again, I'd like to introduce Mr. Bradley Tamm, who is Chief Disciplinary Counsel and, of course, the administrator of the Lawyers Fund for Client Protection. Thank you, Mr. Tamm.
Thank you, Carol. Aloha. And it's always a pleasure of mine to appear before the Senior Counsel Division, for which I am a member, due to the fact that I've done enough turns around the sun. There's one nice thing. This year I turned 70. So it's the only benefit that I've been able to find out so far is that I can now legitimately refer to all the judges in the state of Hawaii as Sonny or youngster. So I guess that means that it's been a long time, and it has. In addition to my title as Chief Disciplinary Counsel, my unofficial title is Chief of the Dead. The dead, the dying, the disabled, the disbarred, the deported, the disappeared. So as a result, I spend a significant portion of my day dealing with situations where attorneys have got to, for one reason or another, exit the practice of law. And unfortunately, a lot of that is an unplanned exit. Gee whiz, you mean we're not immortal? But it starts to weigh on you. Really, from my perspective, it's kind of depressing. It's because so many of these attorneys who are fading are my friends, my colleagues, people I've dealt with over the last 30, 35 years. Past adversaries in particular. It's always, somebody that you battled with in the Coliseum, in a courtroom, and then you start talking to them, and while they're on their deathbed or in hospice or something like that, and it really brings home the concept that we got to start thinking about this stuff in advance. I visit people in the hospital, or I talk with people on the phone that are going through these problems. And that's bad. It's hard, and it's takes a lot out of you, but it's not near as much as the anguish that I personally go through when the attorney has passed away or has, is in a coma or something like that. And I find that I have to talk to the family, to the widow, to the significant other, and try and softly give my condolences, express my concern, communicate what our limitations are, and try and ferret out the stuff that we have to do in order to protect the interests and property of clients. There's a lot of times the family, well, heck, the widow's been married to the lawyer for the past 40 years. She knows what lawyers do. And here her husband has passed away, and out of the blue, she gets a call from some lawyer who's with the Office of Disciplinary Counsel that he may have indoctrinated her into believing that we're a bunch of goose-stepping Nazis. And and here I'm trying to talk sweet, and I find out what kind of money is in the client trust account and what clients' files that they're in possession of. Well, yeah, a lot of times the widow is a little bit paranoid of hearing from me. So I'd like to take every opportunity I have to talk to all of you and help you start thinking about preparing your family for this, preparing your practice for it, and getting ready, because we never know what's going to happen. Back in 2004, I had a stroke, a bleed in my brain, and it was completely unanticipated. I was in my early 50s, and boy, it knocked me for a loop. For a while there, it was touch and go. I survived from it. Luckily, I only lost the vision above the horizontal. I recovered from it, but it brought home the concept that we are not immortal. We got to get ready for the eventuality of it. So let's talk about this a little bit today. Okay, first thing, we just had the introduction. We're going to talk about the legacy that you leave, or particularly sole proprietors leave behind at the end of their professional life. We're going to talk about some recent changes to the rules of professional conduct. And we're going to talk finally, very shortly, about estate planning. If everything goes according to plan, this little talk will take about 30 minutes. And then I hope we've got a lot of time for discussion at the end, because I'm sure you all have burning desires and needs to ask important questions. And if we don't cover it during this presentation today, I am always available to you 7 days a week, 24 hours a day. My cell phone number is area code 808-206-1120. That's 808-206-1120. You also have my direct line that's available on the HSBA bar directory, the website. And that direct line, by the way, even though it's an official ODC phone number, it's actually forwarded to my cell phone. So if something comes up and you got a problem, you call me and we'll walk it out. Okay, so let's go here to our website and take a look at some of the resources that we have on our website. Our website is dbhawaii.org. It's DB is in Disciplinary Board, Hawaii.org, organization. And when you go there, you'll find a tab that says resources. And one of those tabs is past Hawaii bar journals. This one article that is relevant to today's discussion is an article I wrote back in 2019. And that article was called, in the Hawaii Bar Journal, it's called Sole Legacy, Disposition of Files and Funds. And we're just going to touch on a few of the highlights from that today as part of this talk. Now, some lawyers, when they get to the end, they retire. I always dreamed of retirement. I shut down my law firm in 2015. I moved into my bedroom and practiced with a couple of selected choice meaning regularly and reliably paying clients without a staff, and worked part-time for a while from 2015 to 2018. In 2018, I completely retired in March. And by September, I was completely bored to death. And I was very grateful when the Disciplinary Board called me up and told me they had an opening in the ODC and wanted to know if I'd be interested. And I jumped at that opportunity. I don't think it's in my cards to retire. I guess the state of Hawaii says that you're legally suspect when you turn 70, and that's why they don't let judges stick around. Well, I turned 70, and I think at least I got half a wit. You know, I'm still kind of here, and I think all of us are probably, you know, hanging on for quite a bit. We may want to continue practicing law for a while, and I see no reason why you can't. The thing is, we got to understand limitations. I know myself personally, I don't hear worth a damn anymore. I got hearing aids and amplifiers for everything. I don't see too well as I used to, and I sure as heck don't think as fast as I used to. So I've had to make adjustments for aging, but it's up to the individual, and I encourage you all to make reasoned choices. got to understand what the process is of wrapping up your practice and how to get ready to gracefully fade away. What was it MacArthur said at West Point? Anyway, let's talk about the preferred method of going out of practice. The preferred method is to give notice to your current clients. Give notice, and when also I would include in current clients, former clients for which you still hold their property. Okay, even though the case is closed, if you're still holding on to property that belongs to the clients, you should be giving them notice as well. Give notice that you're ending your law practice. This is implicit in Rule 1.4 of the Rules of Professional Conduct. Next thing you need to do is you need to return files and funds consistent with HRPC Rule 1.16. 1.16 is the rule on terminating representation. Now, when I say returning client files, a lot of you go, oh my God, I got a client that's files occupy 35 bankers boxes, and you mean I got to mail all that back to my client? Well, not necessarily. And we'll touch on that in a little bit more detail later on. But under Rule 1.16, you're only required to return to your client papers to which they are entitled. And you're also required to return unearned portions of their fees. Okay, so papers to which they're entitled. When I was practicing, I always made sure that anytime I received a new filing on a client, I sent the client a copy. I never accepted originals. If they brought originals, I made them stand there while I Xeroxed copies, and I gave them back their originals, and I only kept copies. And if they've already been provided with documents, if all you've retained is copies and they've got the originals, it's arguable that they're not entitled to anything that's in your files. So you may have complied with Rule 1.16 in maintaining those files. But the important thing is you've got to take care of this little check mark here when closing down your practice. You got to return papers to the client to which they're entitled, and you've got to refund any unearned portion of your fees. Oh, and by the way, earned on receipt retainers, true retainers, all that kind of thing hasn't existed in Hawaii since 2002. Okay, all advance payments made by the client are property of the client until it is earned. So you got to take care of this. All right. Now, after you've returned files and funds to the clients, next thing you got to do is close your IOLTAs and CTAs. Your IOLTA is your interest on lawyer's trust account. That's your pooled account that you deposit all your client funds into. You may also have what we call CTAs, or client trust accounts. There's a difference between the IOLTA, which is a pooled account for multiple clients, and a CTA, which is a client trust account that's for an individual client. There's a lot of technical details on this, and if you've got questions on it, give me a call later. I won't go into it here much more detail other than the only funds that are to go into an IOLTA account are sums of money that are retained for a short period of time or are not are small in value. If you receive a $1.1 million settlement on behalf of a client and you intend to pay that out in a matter of days, it can clear through your IOLTA. But if you get that $1 million settlement and you've got to hold on to it for 3 months or so, that legally can't go into your IOLTA. It needs to go into a client trust account, which earns interest for the benefit of the client. So if you've got questions on that, give me a call afterwards and we'll walk through the distinction there. All right, the fourth step along the line of wrapping up your practice is destroying files and other documents. Okay, when I say, and I will have you chant secretly to yourselves in this lecture series, one of my favorite sayings is stand up and scream at the top of your lungs, boot camp style, when in doubt, throw it out. I wish every attorney would exercise that as something that they repeat to themselves over and over again. When in doubt, throw it out. And this is to get rid of your files while you're still alive and kicking. Now, your insurance company may differ with me a little bit, but the rules of professional conduct say the only files that you're required to keep are records of financial transactions with your client, which is your client trust account records and things of that nature. Take a look at Hawaii rules governing trust accounts, Rule 4, and it will detail in there that you are only required to keep the financial records 6 years from termination of representation. So if you represented a client for 5 years, then you terminated representation, you got to have 11 years worth of financial records. But as far as what went on in the case, you're not required to keep that stuff at all. The correspondence, the pleadings, and the court documents and stuff like that, there's no ethical requirement that you keep them. Again, your insurance company may differ a little bit, but please don't hang on to these paper files, because if you pass away, you've got the discretion to destroy these things immediately. If you pass away and ODC has to appoint a trustee, we're not allowed to make that distinction. We have to try and find every client and return the stuff. And that's such a burden every year. Do you enjoy paying your $650 a year annual license fee? Well, $250 of that goes to the disciplinary board, and a substantial portion of that fee is the cost of administrating these client files. Last year, I spent over $200,000 in dealing with these long kept files. So please get rid of your files before you hang it up. And then finally, it would be nice when you wrap up your practice at retirement time. This is not a requirement. It's just me getting on my hands and knees and begging you. Write a letter to ODC. Say, you know, I'm hanging it up. I'm not practicing law anymore. And I listened to you. And I went and I closed my client trust account and I returned all my client files. There's nothing left to be distributed. Hope you guys have a nice aloha life or something like that. Just a kiss off goodbye letter to me. What I do is we keep computerized records on every attorney. I will put it in what's called your L file. It's not a disciplinary file. It's just a file L for lawyer, and it's under your bar number, and it becomes a permanent record here. So 2, 3, 4, 5, 10, 15 years later, when I get a call saying so-and-so has passed away, I go look at the L file and I see if I have one of these closure letters in there. That saves me from having to contact your widow and give her the stress and everything else, because I'll have a record that you already told me you got rid of all your files, you closed your accounts, there's nothing left to do. So that's the last thing on my list that I would like to ask for. I have no right to demand it. It's just an option for you. And then after you've done all this, enjoy your retirement. Okay, that's the easy way. That's the preferred way. And there's other situations that we run into. We call it the hard way. Okay, one of those, I'm not on screen share, am I? Sorry. I had started out on screen share and I...
Oh, you're on screen share. We're able to see your presentation.
Okay, so you're on screen share right now?
Yeah, we see your presentation, Mr. Tamm.
Okay, all right, thank you. Okay, whenever I learn that an attorney has died or is in hospital in hospice or something, in the process of dying, has become disabled, disbarred, disappeared, or deported. These are one of the triggering events that causes ODC to open up a case file. And we will first try and contact you if you're still alive or reachable. And failing that, we'll pull your HSBA, most recent HSBA registration document, and take a look to see if you have designated a successor or a practice administrator. Then ODC will contact that individual attorney. Now, you may have noticed that in your bar registration, it asks you these questions as to whether you have a designated successor or a designated practice administrator. And it gives you the option of listing the name of that person. This is quite important because we don't want to bother your family and your widow and your kids. We'd prefer that you have an attorney who can deal with us, that you've planned out, that knows something about your practice. In those cases where they're not available, and there's no designee in the bar registration, ODC will contact. First, we try and find out, did you have any colleagues? If you're in an office share environment, I'll call the people you shared an office with, or your neighbors in the building, attorney neighbors and things like that. And if all else fails, then I'll reach out and contact your spouse, your adult children, and other members of your family to try and put these things together. I really don't like to add stress to people's lives, but it's necessary because our mission here is to protect the public and maintain the integrity of the judicial system, excuse me. And in order to do that, we've got to make contact. I try and ascertain the need for intervention. Does the lawyer have clients, or did the lawyer have clients at the time of the disability? Did the lawyer maintain files of former clients? We had one attorney pass away in 2014, and we found out that he began practicing law in 1952, which is a couple months after I was born. And during that period of time, he had not thrown away a single client file. And it occupied over 5,000 banker's boxes of client files. Oh my God. That cost the bar $160,000 in trustees' fees just to get the files inventoried, to track down clients, and get files destroyed. So these are the things we're looking for: as their client files and as their funds in the accounts. Again, we cannot distinguish between current clients and former clients, because we don't really know if you're still in communication with a client on a closed case. We have to treat them all as current clients. And we're not allowed to make the decision as to whether or not the former or current client needs to be contacted to get their files back. We have to hunt down every one of them, contact them, and give them the opportunity to come get their files. And after we've exhausted all those efforts, then we can go forward and destroy files. But that's very time consuming and very expensive. And that's why we need your assistance in wrapping this stuff up. Now, again, my watchword is for you. It's not for ODC because we can't do this, but for you, when in doubt, throw them out. And when I say throw, I mean securely destroy, have them shredded. Okay. Where it appears that there are files and or funds, ODC may work with your successor to facilitate the transfer of your practice. Now, let me take a moment to talk about the difference between a successor and a designated practice administrator. A successor is someone who, pursuant to Rules of Professional Conduct, Rule 1.17, which is sale of a law practice, has bought your practice and takes over as the attorney of record. Okay, this is controlled by HRPC Rule 1.17, and this is a boon for estate planners. You might come up with some kind of estate plan that allows for the sale of law practice to occur upon the triggering factor, which is the death or disability of the attorney. I leave it up to you and your wonderful legal minds to craft such a mechanism. But this would be a real nice way to do something, particularly if an attorney has a practice which is somewhat profitable. That's what a designated successor does. A practice administrator is not under the Hawaii Rules of Professional Conduct. It's under the rules of the Supreme Court of Hawaii, Rule 2.20. Under Rule 2.20, the court appoints a trustee to basically step into the law practice. That trustee cannot take over individual cases, profitable cases. The only thing the trustee is permitted to do is step into the law practice, collect and inventory client files, both current clients and former clients, send notices to clients, publish notices in the newspaper that you come get your files within 90 days or they'll be destroyed. And the trustee also takes possession of the financial accounts and attempts to identify if there's any unearned fees that need to be returned to the clients. Let's see here. The point is that if you have worked with your HSBA registration and have provided us with a designated successor, that is someone who has bought out your law practice, there's basically nothing for ODC to do other than if you want to take over the IOLTA account, you're going to need a court order, and ODC will work with you to get you an order from the Supreme Court that allows you to take over custody of the attorney-client trust account. There's actually a provision for that in Rule 2.20. And that you get for free. There's no charge involved in getting that involvement of ODC to help you take over custody of the attorney-client trust account. The other option, if you don't go with a designated successor, which is a sale of a law practice under 1.17, if you go with a practice administrator, which is the appointment of the trustee, certain costs can be incurred. Now, the advantage to you of getting somebody to volunteer to be the inventory attorney, the designated practice administrator, is they normally serve pro bono. If they serve pro bono, we don't rack up any costs because the disciplinary board has to pay any fees to a trustee. So we encourage pro bono service. The expenses that we do incur for anyone who, anytime we set up a trusteeship, is we've got to store the files, and storage facilities charge a lot of money, particularly on Maui. It's about twice as expensive as it is here on Oahu. But even on Oahu, the costs for storage spaces are horrendously expensive. The average cost we run into is about $300 to $500 a month. And these trusteeships can take a number of years. So that's a lot of money in storage costs. The other thing is, if you haven't designated a successor, then ODC will go out and find one for you. Now, we try and look for people to volunteer, but usually, unless they know you real well, they're not going to. How many lawyers work for free out there? Yeah, that's a good question. So we end up going to our panel. We have a small panel of professional trustees who work for compensation. Now, each one of these trustees are very generous to the bar. They agree to work for $75 an hour. Or let me put it this way, the Supreme Court won't authorize any more than $75 an hour for the trustees. But still, $75 an hour, that can rack up a lot of expenses. I've had cases that have gone as high as $75,000 in trustees' fees. That comes out of the Disciplinary Board's budget, and we get our money from you when you pay your annual registration fee. Well, Supreme Court Rule 2.20J. If you look on your screen, it says Rule 2.22. It's because this particular page of the rule book started Rule 2.22 on this page. The citation for this particular rule, subparagraph J, is 2.20. This is a trustee proceeding. Under Rule 2.20J, the subject attorney or the subject attorney's estate may be required to pay back the disciplinary board for all the expenses that it incurs in running these trustee proceedings. I spent my career as a lawyer working in bankruptcy. I worked with bankruptcy trustees for about half of that career, And I've got a lot of experience in clawing back funds from people who received fraudulent transfers or preference payments. So I got pretty good at it, and it's not really enjoyable to go after a family and try and claw back the expenses that the bar has incurred in trying to wind up a practice, but it's something that's got to be done. And the bar expects that we keep their annual registration fees low, and we only do that by working efficiently. And I get a court order that says, ODC, you go pursue this recovery, and that we got to do. Now, bear in mind that the wife is not jointly liable with the husband, or husband is not jointly liable with the wife, depending upon whoever was the lawyer, but their estate is. So the first thing I do when we move to appoint a trustee is I open a probate action. If no probate action is already open, I file what's called a demand for notice, which opens a probate case under that the deceased lawyer's estate, and assert an unliquidated claim for recovery on behalf of the Disciplinary Board and the Lawyers Fund for Client Protection. Then later, if a formal probate or informal probate is opened, we're a creditor with a claim. If the family chooses to wait us out and not open a probate case, we've already opened it by filing a demand for notice. And if we find out that there's assets to be chased, we will commence a creditor's proceeding under the probate code and go after it and try and recover the funds for reimbursement purposes. So these are things you don't want to leave as gifts for your family. If you can work with us and provide an easy transition, and in the event of something unforeseen, you've got designated successors or designated practice administrators willing to work pro bono, you've really left a nice gift for your family of relieving them of the stress of these obligations. Now, the Hawaii Rules of Professional Conduct was recently amended to add comment 5 to the rule of diligence. And comment 5 says, to protect neglect of client matters in the event of a sole practitioner's death or disability, the duty of diligence may require that each sole practitioner prepare a plan in conformity with the applicable rules that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. Okay, this rule was added January 1st of 2021. Excuse me, not rule, comment. Comments are not enforceable, but they are instructive, and this explains what the duty of diligence means. Now, are you worried about ODC coming after you with a disciplinary complaint after you're dead? I actually had an ethics call not long ago from an attorney that wanted to know if you could be subject to discipline after you die. And I says, well, last time I looked, it was pretty hard to disbar somebody in heaven. So yeah, you're probably not worried about it, but gee whiz, how else can we get the message across? You need to plan ahead, and that's part of the rule of diligence. So bottom line is, make a plan, prepare for this stuff. And with your files in particular, when in doubt, throw it out. When in doubt, throw it out. Okay, let's go next to Hawaii Rules of Professional Conduct, HRPC Rule 1.16D. This section deals with what you're supposed to do upon termination of representation. And the rule, this is not a comment, it's a rule, this is actually law, says upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interests, such as giving reasonable notice to the client, allowing time for employment of other counsel, and surrendering papers and property to which the client is entitled refunding any advance payment of fee or expense that has not been earned or incurred, and upon request, providing accounting of such funds. This is the rule that tells you what you have to do when you terminate representation. Now, if you've done it right, when a case came to an end and you terminated representation of the client, you've already complied with Rule 1.16D. You already went through your file and found all the legally operative original documents of value and returned them to the client. You've gone through your client trust account and you've refunded all unearned fees. Therefore, if you've terminated properly, the only files that you have left over is just junk that you're hanging on to in case you get sued. It's something to fulfill your records. It's stuff that you could legally destroy, subject to advice from your insurance carrier, of course. That's what should be in your files. Therefore, you can then follow the old adage of when in doubt, throw it out. This is something that only you know about. You know that you've already gone through your files and done all this stuff. If you're dead, if you're disabled, there's no way for ODC to know. That's why we have to spend all the money to go through the process of notifying clients. But if you've done this right, then you're already situated where you can go ahead and destroy these files. I used to do this at the end of each client representation, and I would transfer my files to storage. I think I had an account at Dillingham Self-Storage, and it kept an inventory. And each box was inventoried and numbered, and that box would get pulled after 6 years expired, because that's what my insurance carrier told me I needed to hang on to it for. And at the end of that period of 6 years, those files would be taken out and shredded and destroyed. And we always kept in rotation of that, so that when I finally retired, I was able to close up everything and get rid of all of it. And to this day, I have nothing left over from that closing my shop in 2015. Okay. Oh, let me back up 1 second here on this closing up a client matter. I would like to suggest that when you terminate representation, and please pass this on to the youngins that you work with too. Every lawyer should do this all the way through their practice, is when you've terminated representation, write a letter to the client and tell them, it's been real, it's been nice, it ain't been real nice, but see you later, adios, that sort of thing. A final termination letter to the client to make clear that your representation has ended. This eliminates the possibility, and we see a lot of this in ODC, we get ethics complaints that says, my attorney won't return my phone calls. And it turns out that the case ended like 4 years ago, and the client still believes that you're his lawyer and you've got to return his phone calls immediately. That letter of termination is wonderful evidence to help end a potentially nasty little disciplinary complaint. Also, in that letter of representation, that letter of termination, say, please find enclosed any legally operative original documents or documents of value that I'm returning to you, and a check for your unearned attorney's fees. Or say in the alternative, I've reviewed your files and I find nothing further that you need to be provided, and there's no money left in your client trust account. In other words, you're completely ending this thing and giving them notice of it. And finally, if you've got copies in the files, and I always put this in my letter of termination, I said, I'm terminating representation with you. I do have some copies of documents in my files. If you want them, you got 90 days to come get them. If you don't pick them up within 90 days, I may destroy them without further notice to you. And that, again, communicated clearly I'm no longer representing you. I've returned to you everything to which you're entitled. If you want anything more, you got to come get it within the next 90 days. After that, we are finished. Fine. No more connections. So it's done. And that was always very helpful in eliminating problems with clients as they drifted on later on down the road. Now, I used 90 days. You could use 30 days, 60 days, 180 days. You pick something reasonable, but the idea is you want to get this stuff off your plate while it's still in the forefront of your mind. You still remember this person. I got a complaint last week where the complainant was alleging that his attorney screwed up and didn't return his stuff in 1981. I started to investigate it and looked up the attorney and find out he died in 1994. So that was good. We could close that disciplinary case. But there are some nut cases out there that expect you to remember things forever. So help yourself out, help us out. We'll all make this thing work real nice. Okay. The aging lawyer crisis, estate planning. There's a video. Actually, it's one of these little sessions I gave. It's a brown bag lunch session with the estate planning law section. I gave it back in October of last year, where we talked about the differences between a designated successor and the designated practice administrator or trustee. And I made some suggestions to the estate planning law section about how to design one of these law practice sales. If you're interested in the concept, go to our website, click on the link to the aging lawyer crisis, and it'll connect you with one of those YouTube videos, and you can watch the whole thing. And again, if you got any questions, give me a call, and we'll work our way through it. The need for succession planning is pretty heavy. We're all growing old. The majority of the bar is over the age of 50. I have a bunch of young lawyers working here at ODC, both our full-time and part-time staff. A lot of them were not even born when I was in law school. And I think that they're going to have a wonderful practice in a few years, because most of us will be gone. The world is their oyster. But there's going to be some painful times coming up as we're aging out. And if we all, and the number one thing I promise myself every day when I come to work is I am not going to ask the bar to increase your fees every year. And in order to keep those fees down, we have to jump through all kinds of hoops. And I need help from every practicing lawyer to help keep these things down to a minimum so we don't end up raising attorneys' fees. You know, the disciplinary fee, I think in 1975, and ODC was created in 1975, the disciplinary fee back then, I think, was $65 a year. And had that disciplinary fee been indexed with inflation, your current annual disciplinary fee would be $575 a year. You're only paying $250. So ODC has worked to keep the expense down, but we'd like to keep it lower. I know that my license in California costs less than my license in Hawaii. So but everything's more expensive here, isn't it? Okay, in summary, disciplinary board budget requires $200,000 a year just to wrap up aging lawyers' law practices. So us seniors could do a lot to keep that down. If you got any questions on how trusteeships are orchestrated, you can take a look at the 2021 version of RSCH 2.20, which is trustee proceedings. You also have to understand that when lawyers check out without having advanced plans, it not only costs the lawyer's family, the lawyer's estate, there's also the cost to the clients, the public, the judicial system, and the profession. These costs are incalculable. Now, I'm not ready to retire yet. You may not be ready to retire yet, but I do try and be reasonable and open to suggestions from people. Things happen and we start to slip a little bit. And if you start making mistakes, one of the options you have available to you is the Attorney and Judges Assistance Program for the Supreme Court. You can call the AAP anytime and talk to them about what kind of difficulties you're experiencing. If you don't want to talk to me, because I'm the chief of the cheese eaters over here at the Rat Squad, you can call AAP. Communications with AAP is absolutely confidential, and they may have some information for you or be able to get you some help. Things happen as we grow older. They can be embarrassing. For me personally, I've been dealing with this long enough. I've seen enough that nothing really surprises me anymore. And I like to think I'm pretty compassionate and I'm willing to talk to you, but just do something. Don't internalize it. I lost my father-in-law to prostate cancer. He was just embarrassed to say anything to anybody. So something that would have been a very curable issue, he waited too long until it was incurable. And that taught me a big lesson that we need to reach out. We need to talk to people. Okay. And at that point in time, I will tell you that this program has been brought to you by the Office of Disciplinary Counsel. And I am now open for questions.
All right. If anyone has any questions, please put them in the chat box and I will read them. And we do have one question. Is there any requirement to destroy electronic files? And may the records of financial transactions with clients be retained only as electronic records?
Okay, let me answer the second part first, because that's the easiest one to answer. Yes, the rules specifically provide that electronic records are acceptable. In fact, nowadays, almost everything is electronic. All my bank records with my personal bank accounts, that's all electronic stuff. My investment accounts. I don't get copies of checks anymore. What you do is you download copies off the internet. So yeah, electronic records are absolutely acceptable. Now, I did get a call from a lady a couple of years ago. She was ready to retire and she asked me what she should do with her files. And I says, you need to shred them. And she said to me, you mean I have to print out all my files and then run them through a shredder? Madam, are you telling me that all your records are electronic? She said, yes. I says, okay, look at your keyboard. In the upper right-hand corner, you'll see a key that says DELETE. Do you see it? She says, yes. I said, push it. And that's kind of the answer to that question. If all your files are electronic, all you got to do is delete them. Now, some of you that are real savvy with electronics are going to come back and say, well, you don't really delete anything just by saying delete. Okay, well, that's true. To securely destroy something, talk to an IT specialist and have the thing purged out of your system. But electronic files are a lot easier to deal with. Again, in getting rid of them, if you're the attorney. If all your files are kept on the cloud somewhere and you die and ODC appoints a trustee, we got to go over and take over that cloud record. And we've got to treat them the same way as we do paper records. We've got to try and identify the last known address of the client, write the client a letter, give them an opportunity to claim the files. So again, as with paper records, same applies to electronic records. When in doubt, throw them out. Now, the nice advantage of electronic records for ODC is we don't have to worry about legally operative original documents. Now, I've used that term several times. And you might say, well, what does that mean? Legally operative original document is a document that has some kind of legal effect to it that only the original will do. Typically original wills. If you got a PDF copy of a will, it's not a legally operative original, right? How about an unrecorded deed of conveyance of real estate? You know, what we used to call them pocket deeds, where you'd execute a deed and carry it in your pocket until you needed to spring it on somebody. It's not recorded, but it's fully executed, just not delivered yet. Those are legally operative documents, and there's a special rule for handling those, but that doesn't apply in electronic circumstances.
All right. And just another friendly reminder, I have sent Mr. Tamm's handout in the chat, so if anyone wants to download it, it's right in there. All right. Next question. If you have a group of lawyers who work in a particular area of law, could they form a pool of designees who take on the case of the next person who passes?
The short answer to that is yes, but subject to HRPC Rule 1.17, which is saleable law practice. The distinguishing characteristic in there is, understand, clients are not the lawyer's property. We would like to believe that the clients are our property, but they're not. They're our clients. They're the principal, we're the agent, right? So you can't just willy-nilly sell your client to somebody else. 13th Amendment comes into effect there. In order to transfer a client from one attorney to the next, it does require client consent. Now, that consent can be handled a variety of different ways. Rule 1.17 also includes a provision for implied consent if the client fails to respond within a reasonable period of time. But you need to read Rule 1.17. And one thing I'll offer you, if you're looking to do one of these deals, I can't give you legal advice, but I'd be more than happy to look at your plan and give you my opinion as to what areas of the rules of professional conduct are implicated by your plan and allow you to adjust it. I'm eager to see these plans. And you got a good idea there, a bunch of lawyers that are working on the same area of practice. I think that would be a unique and interesting way to handle things. Keep me involved in the loop because I'm excited about this. Oh, one other thing, please. A lot of my presentation, I talked about sole practitioners. I'm not after sole practitioners. Don't have any anguish against sole practitioners. But when it comes to succession planning, the only ones we have problems with is sole practitioners, because if you're in a partnership, an LLC with multiple members, or a limited liability partnership, or any of those kind of law firm constructs, all your partners are legally liable to handle your affairs when you pass. It never comes to ODC. It's only the sole proprietors that ODC has to deal with, because legally there's nobody else there to step in.
All right, next question. What are the options for dealing with your license at the end of or during a break in practice? Surrender, suspension, or etc.?
Okay. I don't know. HSBA may yell at me for this, but I understand that if you're over the age of 70 or 75 and you're inactive, they don't force you to pay your annual renewal fee. Is that true, Pat? Wave your hand up or down. I don't see any response. Oh, Pat, yeah, okay. Yeah, is it 70 or 75? 70 or 75? Anyway, it's one of those. And so if you don't want to go through the humbug of surrendering your law license and you're really an old fart, which is, older than me, just, go inactive and you don't have to pay your fees every year, and nobody's going to yell at you. The other thing is, if you're under that magic age, which is 70 or 75, you can go inactive, and inactive means you're still a lawyer, you're still subject to discipline, but you only have to pay a smaller fee, and I think it's $150 a year as inactive. Now, if you want to resign from the practice of law, whereas you're no longer a lawyer, you're done with it, you want no obligations, you don't have to pay any fees, you just want out, is complete retirement. There's two ways to resign. One is a resignation in good standing under Rule 1.10 of the Rules of the Supreme Court. And that you'll find it on the HSBA's website. They've got a little template that you follow for a motion with the Supreme Court. You get an affidavit signed by HSBA, by the ODC, and by the Lawyers Fund that says that you're in good standing, you've got no disciplinary charges pending and no Lawyers Fund claims against you. And it's a fairly quick process, and your resignation is accepted by the court. Problem is, once you resign, you can't get back in unless you go normal admissions and retake the bar and stuff. So not too many people go through the resignation path. The other resignation is resignation with disciplinary charges pending. And those are for people who are in trouble with the ODC. And that's actually a consent to disbarment. We don't need to talk about that. There is no retirement from the practice of law as there are in other states, at least presently in Hawaii. I think I answered the question, did I?
Okay, next question. I have a former client I have not been able to locate for 4 years to refund balance on account. Any guidance on this one?
Oh yeah, this is one which is not in the rules. So I'm going to give you my my view on it, and but with the qualifier that any successor in my position may charge you if you follow my advice. No, the first thing I ask and this question comes up regularly, you got $1,000 in the client trust account that belongs to the client. You can't find the client. The first thing I ask, are you on a flat fee retainer or are you on an hourly contract? If you're on a flat fee retainer and it doesn't have a provision for charging hourly rates outside, you're kind of screwed. You got to find that client. But if you got a flat fee retainer that has a provision for additional charges on an hourly basis, or if you have an hourly agreement, then is it unethical to spend time trying to find the client to refund the fees? And each time you try and find the client, you incur a legal expense, a charge against that client retainer. And let's say I spend 15 minutes running a Facebook check on the client. I spend an hour doing a Westlaw public record search on the client. I spend 20 minutes talking to an investigator on doing a skip trace. And each time that you make these reasonable inquiries, now just don't grab $30,000 and say, I tried to look for the client, but make reasonable efforts to locate the client. And in the process, that surplus in the client trust account whittles its way down and eventually comes to zero. And when it's zero balances, you no longer have an obligation to refund anything because you've earned it all. Now, a little bit of caveat, if you look at Rule 1.5, which is fees, and Rule 1.15, which has to do with with holding client property, every time you make a charge, you need to mail to the client notice that you have taken money out of the account. So you send it to the client's last known address. If it gets returned, it gets returned. I mean, you've just complied with the rules. But I've had a lot of people call with that question. It's a relatively small amount of money. It's a fairly simple way of resolving it. I know that when I closed my practice, I had $275 left in my account belonged to a client I couldn't find. I used that excuse in doing it myself, and I'm comfortable with it. But I did have a call from somebody the other day that had $37,000 in his client trust account, been there for 7 years, and he knows the client died and he doesn't know who the client was succeeded by. That's a problem. And that's a problem that I told him you should consult with an attorney of your choice and at your expense.
All right, next question. This one's a two-parter. Does a designing attorney assume any liability in the determination of the need for protective action? What if the client in the mainland insists on having the file mailed and does not want to pay for the shipping?
Okay, that problem has come up a number of times, and we've always been able to dance around it a little bit. One of my jobs, in addition to being Chief Disciplinary Counsel, I'm also the Disciplinary Board's Trustee Administrator. Now, trustees that are appointed by the court, they work for the court, they don't work for ODC. But the Trustee Administrator at ODC is charged with oversight of trustee functions. We kind of function like the United States trustee does in a bankruptcy case. So trustees call me and ask me how should they handle different things, and we work with them. But ultimately, the decision rests with the Supreme Court on how to deal with the situation. We had one valuable piece of art. It was an original oil painting. The client wanted it returned, but the client was in Utah, and we needed to ship it to him. It had to be packaged in a wooden crate, and it had to be shipped and insured. And the client resisted paying for it, wanted us to pay for it. And we just told him, no, you're going to have to advance us the costs, or we'll ship it COD. And when it finally came down to it, I put my foot down because it was going to cost something like $1,500. I told him, I says, well, I'm going to file a petition with the Supreme Court and ask for permission. It's what I call a mother may I. Whenever you're faced with these situations where you're unsure how to proceed and you're under court supervision, nothing like getting a court order, being cloaked with absolute judicial immunity for following orders. And the client in that case folded and sent us in advance to cover the shipping and freight costs. It's more questionable. The more common problem is the attorney doesn't want to pay for copying the file. Sorry about that. There is a lot of case law that the client is entitled to return of his file. So if the client asks for it back, you can't hold hostage to the file, demand that they pay the copy costs or anything else. If you want to retain a copy of what you sent to the client, you do that at your own expense. And for God's sake, don't tell the client, well, I'm not sending you your file until you pay me the $800 that you still owe me from the last invoice. Because if you do that, you're going to end up getting a call from ODC, and it's not going to be a call from me in my role as Trustee Administrator, because that's an ethics violation.
All right, next question. Are scanned medical records typically sent by an insurance carrier to me considered as the client's files, or can they be destroyed or deleted after 6 years?
Well, first of all, there's no 6-year rule except for client financial records. You know, understand that your insurance carrier may want you to hang on to it. I had a guy, when I got sued for malpractice, the attorney who defended me is now on the Intermediate Court of Appeals. And I asked him, I says, what does the insurance company want me to do? And they'd prefer you keep the files forever. Well, heck, we're not the National Archive, you know, so I don't do that. But you get sometimes, and this also happens with criminal defense attorneys, you get discovery from the prosecutor. Some of this stuff is not supposed to go to the client. It can cause the client injury, or the client can abuse the files if they get a hold of it. These are unique circumstances that have to be dealt with on a case-by-case basis. And for that, you need to contact me individually, and we need to work our way through it. And I'll work with you on it.
Next question. Regarding the prior question of a pool of attorneys in a particular area of law, could the pool be for the purpose of appointing a designated trustee?
But yes, there's a succession plan or designated practice administrator. two different rule schemes, and you could conceivably put together something kind of like a HUI, where you've got a group of people that are all working towards a common effort there. And it sounds creative and it's exciting, but just bear in mind there's particular rules that you need to be cognizant of. The nice thing about being a designated practice administrator functioning under Rule 2.20 is you are absolutely immune from suit, which is Rule 2.8. You enjoy judicial immunity for your conduct as a trustee. But remember, as a trustee, you're not allowed to take over the juicy cases. Now, when we wrote the trustee rule in 2021, I actually made a provision in there where a trustee can surgically extract a juicy case from a trustee assignment. But that requires permission from the court. It also requires compliance with Rule 1.8, which is business transactions with clients. And you can look at 1.8 to get familiar with that. So we've made some changes that make it more attractive to become a trustee. But the nicest thing about taking over somebody's practice as a trustee is you enjoy immunity. You don't have to worry about the dead guy's screw ups. Whereas in a 1.17, where you purchase a law practice, it's like anytime you purchase an ongoing business, you purchase their liabilities along with their assets. So there may be reasons why you want to balance the difference between a successor and a practice administrator.
All right, and the final question in the chat box, if an attorney has complied with termination letters, return of client monies, return of client entitled documents, and periodic destruction of paper files, is there any provisional way to notify the ODC of such prior sorry, I got lost a little bit there. And periodic destruction of paper files, is there any provisional way to notify the ODC of such prior to the closing the attorney's practice?
Well, you can informally contact us anytime. One thing is on our website, if you look on the contact page, there's a portal for submitting inquiries to ODC. That's a preferred method of doing it. Anytime you go to the ODC website portal and you send in a hotline, e-hotline inquiry, it comes to me personally and I answer it usually within one or two business days. You can also just send us correspondence. And if it doesn't relate to any particular disciplinary case pending, it goes into your L file. And your L file is a permanent record that we keep here, which is if you just want information to go to ODC, if the ODC knows about it sometime in the future, just send us a letter. Our administrative department will just put it in your L file. So you've done. I hope that answers the question. I didn't really quite understand it though.
All right, thank you, Mr. Tamm. This presentation is being recorded and will be uploaded onto our YouTube page or on the SCD webpage on the HSBA website. With that being said, I will now pass it over to Carol, who will do our closing remarks.
Thank you, Desmond. Good job on the questions. And Chief Tamm, it's a lot of very, very valuable information today. And as you know, I've been a proponent of succession planning for decades. So very much appreciated. I would also like to invite our audience to our next presentation. Kind of switching gears, it will be Thursday on October 6th. Following the Senior Counsel Division Board meeting. And this one's going to be a follow-up. I think the pithy title of it is something like Medicare Made Easy Part 2, but something along those lines. So please look in our newsletter and take a gander at that for other and different information. And I do highly recommend the Disciplinary Board website. It is a treasure trove. Thank you, Chief Tamm.